Hi, good morning, good afternoon. Welcome to Love Doesn't Equal Law, the importance of estate planning for committed but unmarried couples. My name is Sarah Kurth. I am founder of Life, Death, and Paperwork, where our goal is to normalize estate and end-of-life planning conversations, especially for singles, unmarried couples, and those surrounded by chosen family. Our agenda for today: first I have a few disclaimers and a few thoughts to consider as we begin. Then I'll help you understand your situation as a committed but unmarried couple. We'll walk through a few basic legal concepts. Then I'll walk you through what it looks like if you don't make a plan and why you probably won't like it. Then we'll look at what happens if you do make a plan, and then I'll help you take action by giving you a few next steps. Before we begin, I have to give the standard legal disclaimer. This presentation is for general education purposes only. It is not intended and should not be considered legal advice. Laws and rules vary significantly based on location, and what is appropriate for you varies significantly based on your circumstances and your goals. Contact an attorney or a medical or financial professional for advice specific to your situation. Considering the eventuality of your death and estate planning can be emotional topics. It can unearth lots of emotions and memories. So a few thoughts and a few questions to consider as we begin. Consider these questions and journal about them if you're so inclined. First of all, why did you take this workshop? What has gotten you thinking about estate planning in the first place? Next, have you made any end-of-life or estate plans for yourself? Where are you in this process? Next, what have your experiences been of others' estate planning or lack thereof? I find a lot of people who come to me looking for information and resources do so after somebody close to them have died without doing any planning, and the resulting chaos has made it clear to them that they do not want to leave a similar situation behind for their people. Finally, what words or concepts come up with you when you think about end-of-life or estate planning? Understanding your situation as a committed but unmarried couple. Marriage comes with vows and obligations, but it also comes with a list of benefits and protections. If you are not married, most, if not all of those protections go away. Unmarried couples are not automatically entitled to the rights of inheritance or the right to make healthcare or financial decisions. If you die without a will, intestate is the fancy legal term for dying without a will, state law will determine who will manage your estate and who will get your stuff. Laws vary a bit by state, but are always based on some version of figuring out your nearest blood relative. Critically, a partner you are not married to does not figure into that. The default rules aren't what most people would expect. They for sure aren't what most, if any, unmarried couples would want. Overcoming an objection that some unmarried couples have to doing estate planning. If I wanted to do paperwork, I would just get married. I get it. Really, I do. But our systems are built around a few assumptions about adults. That they will be married, and if they aren't married, the most important people in their life will be your family. These are largely antiquated ideas that don't reflect the lives that many of us live today with unmarried partners or chosen families. But if you want to be involved in your partner's medical, legal, and financial life when they are incapacitated or after they die, paperwork will be required. Either marriage paperwork or estate planning paperwork. Ideally, both. Just a quick note here, some states recognize common law marriages. This is when a couple who have never done any marriage paperwork live together and present themselves as a couple. After a certain number of years, which varies by state, the state will consider you common law spouses. If you live in a common law state, talk to an attorney to ensure you are planning accordingly. It can get very complicated very fast when talking about the intersection of common law marriages and the legal rights that do and do not come along with that. This workshop is really talking about couples who are a couple but are not legal or common law spouses. A few very basic legal concepts as we begin. I do not intend to give you a law school 101 primer here, but understanding a few basic legal concepts will help you understand the specific scenarios that we're going to be talking about in just a moment. Estate planning can get very complicated very fast. I intentionally kept this presentation very high level and straightforward. I'll use plain English, but I'll occasionally mention the legal terms just so you hear them and know what to expect and don't freak out when you hear them in the wild. In an ideal world, the people who love you the most and who are the most involved in your life would make the choices for you and get your stuff, but that is not the case. As you reach the end of your life and after your death, you are dealing with two institutions that are very old-fashioned and very red-tapey: courts and medicine. Courts and hospitals want cut and dried relationships of blood or marriage, or they want paperwork. They do not want to have to quantify friendships or relationships. One very basic legal concept that is vital in estate planning is determining who will be involved in what. When dealing with medical, legal, or other official questions, we need to consider who can act, what can they do, and according to what rule or what document is allowing that person to act on your behalf. Another concept that is important in estate planning is understanding the difference between you and your stuff. Who can make decisions for you as a person may or may not be the same person who can make decisions about your stuff. Your person includes choices about your medical care when you are alive and what happens to your body after your death. For example, if you're going to be buried or if you're going to be cremated. Your stuff is your stuff while you're alive, your bank accounts, your clothes, your car, and everything else you own. After you die, your stuff becomes your estate. Note that while the word estate may conjure up visions of mansions and jewels, estate is just the fancy legal term for your stuff after you die. Everyone will have an estate. For the purposes of this conversation, we'll only be considering what you own individually. Items owned jointly with others is an important tactic for unmarried partners, but those items are dealt with differently in estate contexts. So for what we're talking about here, we're really only talking about your stuff. I found the best way to convince people to do some estate planning is to let them know what will happen if they don't do any planning. The specific rules here vary by state, but these are the general defaults. In almost every state, if you don't do any paperwork, it will look something like this. If you don't do any paperwork and you are alive and with capacity, so you're just a person walking around in the world, who is in charge of your body and making decisions about your health care? You are. Who is in charge of your stuff and your money? Again, you are. If you are alive and incapacitated, the example that is always used in law school is you are hit by a bus and you're in a coma. Who is in charge of your body and making decisions about your medical care? It is your spouse or your next of kin. And it is vital here to note that next of kin is your spouse if you are married, or your nearest blood relative if you are not married. Partners you are not married to are not considered next of kin. If you are incapacitated, who's in charge of your money and your stuff? No one. After you die, who's in charge of your body? Again, it is your spouse or your next of kin. And who is in charge of and who will get your money and your stuff and your estate? Once again, it is your spouse or your next of kin. This is not the situation that many committed but unmarried couples would choose. I don't know many unmarried couples who would prefer that a cousin or a second cousin make medical decisions for them instead of their unmarried partners, or who would want their aunt or their uncle to get all of their stuff after they die instead of their partners. But if you don't make any plans and you don't do any paperwork, that situation becomes much more likely. So, what does all of this look like if you do the paperwork? If you are alive and have done the paperwork and you are alive with capacity, this will look very much the same. Who is in charge of your body and your medical care? You are. Who is in charge of your money and your stuff? Again, you are. There is an option here to appoint a power of attorney if you want somebody else to be able to sign on your bank accounts or to sign contracts on your behalf, but that's optional. If you are alive but incapacitated, who is in charge of making decisions about your medical care? It is your healthcare agent, or sometimes called your healthcare proxy. And this person is appointed via either an advanced care directive or a living will. The term that's used varies by state. If you are alive but incapacitated, who is in charge of your money and your stuff? Your power of attorney, who has been appointed via a durable power of attorney form. What happens to your body after you die if you've done the paperwork varies based on where you live. In most states, the decisions about what will happen to your body after you die are made by the healthcare agent or the healthcare proxy appointed in your advanced care directive or your living will. But in some states, that healthcare agent appointment ends immediately at your death. And in those states, you need to appoint the person you want to make decisions about your body disposition using a body disposition form. What this form is called, again, varies by state. Who is in charge of your money and your stuff in your estate if you die after having done your paperwork? Your estate will be managed by your executor, who is appointed in your will. And your will is also the document where you will list who gets what in your estate after you die. There's also the option here for some types of account to name a beneficiary directly onto the account. Those accounts will go directly to the beneficiary after you die via the terms of the account. This is a great way to get your accounts directly to the people you want to get those accounts without having to go through probate or the court system. So hopefully I've convinced you that some estate planning and paperwork is necessary. So what exactly does that mean? Here are a few places to start. For more information on any of these items, talk to an attorney, an accountant, or a financial planner, or access reputable DIY resources. First of all, consider how assets are owned. Unmarried partners should be intentional about how assets are titled and owned, especially large assets like cars and homes. One way to avoid estate complications is for assets to never become part of the estate. Owning assets like houses, cars, and other property as joint owners ensures that the survivor will be able to retain ownership after the death of one partner. As I just talked about, many of your assets can be transferred to others at your death automatically and without the involvement of the probate court. Adding a named beneficiary to a retirement or investment account, or adding a payable on death beneficiary to a bank account will make transferring those assets easier after a death, since those assets will not have to go through probate. Next, complete an advanced care directive or a living will and the appointment of a healthcare proxy. The names of these documents vary by state, and in some states it's 2 separate forms, and in some states it's 1 form with 2 parts. A living will is a document where you will document what medical choices you do and do not want made if you are ever incapacitated and unable to make decisions for yourself. The appointment of healthcare proxy or healthcare agent form is the form where you will name the person you want to make medical choices for you if you cannot make those choices for yourself. An advanced care directive is a single form with two parts, the first part being a living will, and the second part being the appointment of a healthcare proxy or a healthcare agent. A good place to start here is with your health insurance provider. Most have forms that you can use. Next, write your will. Your will is the document where you will name your executor, the person who will be in charge of your stuff and managing your estate after you die. And your will is where you will list who you want to get your stuff. Since your unmarried partner is not automatically entitled to anything in your estate or to manage your estate, a will ensure that your stuff will be managed and distributed to them. Next, consider a durable power of attorney form if you want your partner to be able to deal with your financial accounts, pay your bills, or deal with other business affairs if you are alive but incapacitated. Make sure your power of attorney is durable if you want it to remain valid in cases of incapacitation. In most states, the healthcare agent or the healthcare proxy rights that we just talked about above in a living will or an advanced care directive includes the right to decide what happens to your body after you die. For example, if your organs will be donated or if you're going to be buried or cremated. However, in some states, body disposition is not included in those rights, and a separate release or a separate waiver is required to ensure that your preferred person is making those choices. To make this extra confusing, what this form is called varies by location. Finally, document your stuff. All of your accounts will have to be closed, and all of your stuff will have to be located and distributed after you die. Documenting important information and accounts will make that process so much easier. Document information like where your accounts are, where your important documents are, and important digital accounts and passwords, for example, email and online banking. That's a lot. I know that's a lot. If you want to start documenting your stuff but aren't sure where to start, I have a list of items to document attached below as a PDF. If you want even more guidance on what you should document, I have a full checklist available for sale on my website, and again, a link will be below. So I just threw a lot of information at you. I know that can be overwhelming. If you remember nothing else that I just talked about, remember that if you don't do any planning, your unmarried partner is not entitled to your stuff. They are not entitled to have a say in your care and will not have a say in what happens to your body after you die. So do the paperwork to ensure that your partner will have a role in your life, in sickness, in health, and after your death. And the document that I always recommend people start with is an advanced care directive or a living will and the appointment of a healthcare agent to ensure that the person you want to make medical choices on your behalf is able to do so, and that your person and your medical team will know what choices you want made in case of incapacitation. Thank you.